My Lords and Your Ladyship, now enough has been submitted, so I'm not going to repeat what all has been submitted. At several places in the Constitution, term subject to law is being mentioned, and more specifically, there are 4 rights, fundamental rights. Article 14, Article 20, 22 and 28.
14, 20.
20, 22 and 28.
And what about them?
My Lord, these rights are exercised or provided subject to law. Now, right to privacy, for example, is subject to law. The Constitution acknowledges, recognizes it. But what it does not say is what that law will be. So the distinction that I'm attempting to draw here is the argument which was made before Your Lordships that because Article 191 does not say that it's an Act of Parliament, therefore an Act of Parliament perhaps will not be included in it, or this term law will not cover an Act of Parliament. And I'll come back to the provisions of the Constitution which use term Act of Parliament.
Why did you exclude 19A?
19A is, my Lord, because I'm only focusing on 19A, of course. 19A, I'll be coming to it.
Similar language,
subject
to regulation
imposed
and
by
reasonable restrictions imposed by law.
And I'll be coming to it. I'll be coming to it because the 2017 Act.
Why do you want to exclude it from?
For now, I'm just focusing on one thing, which is that the subject to law as used in 191 in fact confers legislative competence. And I'm drawing parallels between 191 and these provisions, but I will be coming back to Article 19A and such other provisions in, for example, 6.3, Article 6.3 of the Constitution, which also confer legislative competence, and my Lord is aware.
Are you saying that the subject to law used in Articles 14, 20, 22, 28 are of a different species from the term, or maybe it's not exactly same term as used in Article 19A?
No. Okay. What I mean to say is that merely using subject to does not in any manner take the competence away. For instance, Article 6, Clause 3 says that a punishment for high treason will be provided by law. The term is used provided by law, and in Article 19A it says imposed subject to such restrictions or regulations as imposed by law. All of these, interchangeably, they confer legislative competence, and the 2017 Access to Information, Right of Access to Information Act 2017 draws its legislative competence from 19A. It does not draw its legislative competence from any of the entries 1 through 57 of Part 1 of the Federalist or Federalist. The term law, my respectful submission, my Lords and Your Ladyship, is it includes 2 sources. One would be a positive law, which in this case would be an Act of Parliament, and the other would be precedents, binding effect of the legal precedents. Generally speaking, this is what the term law has come to be understood in our jurisprudence. And the binding effect of the precedents is duly acknowledged under Article 189 and 201 of our Constitution. But what it does is, it does not exclude an Act of Parliament. It, in a way, expands the scope of what can happen. For example, right to privacy, it says subject to law, it does not say subject to an Act of Parliament. So it can be so that the courts have expounded right of privacy in a certain manner, then those precedents or those judgments of the court will also be treated as having the effect, or this right will be construed in accordance with what the courts have also held. But it does not exclude Parliament's right to make an act. So my submission, Lordships, is, and Your Ladyship, is that the term law as provided in Article 191 does not preclude or does not exclude the Parliament's right to legislate. My lords will notice that this provision has not undergone any amendment ever since the Constitution has commenced, Article 191, and so has the preamble. So while Parliament was acknowledging and making its obligation, imposing an obligation upon itself and all other organs of the state to fully secure independence of judiciary, Parliament at the same time did not give up its right to legislate on matters which may relate to regulating practice and procedure of the Supreme Court. And in my CMA, I have, and I walked your lordship through the history of how the pari materia provision of Article 199 has evolved over the years. And I had submitted that it is, in fact, the executive's role which was eliminated by the Parliament from this process in 1973, which the executive through the President has had prior to the 1973 Constitution. But what it did not do was, it did not give up its own right.
But if you draw this analogy between what was happening prior to the 1973 Constitution, where the rule-making power was subject to previous approval, Governor General, President, so on and so forth, that power which you say was in the executive branch, and that has now been taken away. Is this, if I've understood you correctly? That power was of what I may call a passive nature. In other words, the President, Governor General could not have initiated rule or exercised rule-making power. It was simply you, Supreme Court, make the rules, but they've got to pass muster with the executive branch before they come into effect. So if this is the analogy that you are drawing, then why ought not the law-making power that you say vests in Parliament in terms of the word law, why should that also not, although it remains there, and as you say, it has never ever been exercised prior to being provisions, but simply something that Supreme Court has to keep in mind when making rules?
Understood, sir. Barring Government of India Act, all other subsequent constitutional frameworks, constitutions that we have had, there was always legislative power. The rules were always subject to law and constitution.
Our 56 Constitution.
56 Constitution, in fact, went a step ahead.
Uski language farak hai.
Ji, 170 said that until an act of Parliament is made in this behalf.
That's a different language.
So it was actually, it went a step further.
What happens after?
And then subsequently 62 and 72, it says subject to the Constitution and the law with the prior approval of the President. So what is happening here is, and barring Government of India Act.
Government of India Act.
Government of India Act was totally prior approval in his discretion, and that's about it.
No, but Government of India did not have any legislative engagement at all.
Yes.
So what I'm saying is, if you look at it in the historical context, and I'm now focusing on the analogy that you're making, that previously there was the executive plus the legislative. The executive was purely passive as far as I can understand. So why should not, on that analogy, the law-making power or the law part of it also be regarded not as an enabling power, as a whatever restrictive, limiting power, or whatever in whatever sense?
One reason perhaps could be that till 1972 or when the 1956 rules were made, because there was a prior approval of the President already there, the legislature chose, and in fact, in 1956, because third schedule applied, until such time it applied when the Parliament actually made these regulations, to the exclusion of, in fact, the Supreme Court, the 1956 Constitution, it did not. So there was, the Parliament chose not to act. What I'm submitting, my lords, is that Parliament's choosing not to act or choosing not to act does not, or it cannot be inferred that the Parliament has given up its right.
No, but on the analogy that you make, then the fact that Parliament since 1973 did not choose to act, well, you can go back to 1962, I guess. Certainly since 1973 it did not choose to act, but is not an indication that Parliament has given up anything, but is an indication that Parliament has recognized that this is not an enabling power.
My lord, that would then
Therefore-
giving
and
a
therefore there
meaning
was,
to.
and therefore there was nothing for Parliament.
And
to
that
do.
is why I had referred to Articles 4, 20, 22 and 28 to submit that the term law or in 19A when it is.
There, Mr. Attorney General, the use of the word law over there, I think, has to be read with Section 8. Because Section 8, Clause 1 is the controlling section which says the state shall make no law. Right?
Article 8.
Article 8 shall not make any law which violates them. And then when you look at the fundamental rights and where it says subject to law, that takes color from as an exception to what is prohibited by Article 8 Clause 1. So that's perhaps, I mean, I'm putting this question to you that the analogy that you seek to draw from use of subject to law and fundamental rights perhaps is not correct because the context over there is totally different.
My Lord, if I may. Now, Section 8, Article 8, Clause 2 places a barrier on the state to not make laws which in any way abridges these rights. But what in turn Articles 14, this language in Article 14, 20, 22 and 28 is doing is it is actually enabling the Parliament.
Therefore, actually restricting.
No, restriction is there in under Clause 2 of Article 8.
Therefore,
Restriction is there and here it is enabling.
the reason why it is enabling is because it seeks to balance the overarching restriction imposed in Clause 2 or 1 of Article 8. But that is not the position over here in Article 191. So the analogy that you seek to draw or the assistance that you seek to draw from the use of this phrase in those fundamental rights perhaps is not correct. What would you say to that?
My Lord, the language in Clause 2 of Article 8, when read with what is provided in Article 14, and if I may just now read it out. Clause 2 of Article 8. It says that state shall not make any law which takes away or abridges the right so conferred. And then, so this is a broader constitutional statement, a requirement that no laws which abridge those rights.
Apparently blanket prohibition.
Blanket provision. But the carve-outs in section Article 14 there.
So that the carve-outs therefore are to enable. This is
Yes.
this is you
Yes.
cannot do it at all. So that may be then regarded as enabling.
Yes.
But even over there, it is not to destroy. It is
No, that has to wait. This has to wait whether the destruction part has come into force or not, but this has to wait.
But 191.
When
is
I come to independence of judiciary, this has to wait.
My question still stands. 191 is totally different.
No.
What analogy do you, what assistance do you draw from subject to law?
Exactly
using-
what my Lord has just pointed out. It is enabling provision.
No, but it is enabling.
Enabling and in the context. Now, in the context of what you just said.
उसका काउंटर फिर क्या है ना? देखिए जो सब्जेक्ट टू लॉ फंडामेंटल राइट्स में इस्तेमाल हो रहे हैं, दे काउंटर बैलेंस आर्टिकल 8.
Yes.
ठीक है?
And Article 191's counterbalances independence of judiciary.
Sorry?
Article 191's counterbalances independence of judiciary.
So the
That
independence.
no law which affects independence of judiciary, and that is why I had
That is
submitted,
your
please
submission.
wait for this submission on independence of judiciary. That might just answer what you just pointed out.
See, if you're saying the counterbalances the independence of the judiciary, that is the entire argument here.
So इसीलिए उस पे जरा
That
वेट कर लें कि मैं जब उस पे
legislation
सबमिशन करता हूँ तो that might just
एक बात तो ये है कि this legislation affects independence of the judiciary.
मैं ये
And
इस पे
if-
अभी आपकी
if
observation.
it comes to, we come to the conclusion that that it does, then obviously the restriction that 191 places is correctly placed, number one. Number two, the word law appears in the Constitution more than 200 times.
Yes.
Now, are you arguing that wherever the word law is used, it is used only in one sense, and that is an enabling sense? Or is it more accurate to say anywhere where it is used, like you have just read Article 8(2) and 14 and 20 and 24, it has to be read in that context? It's one size fits all नहीं है.
As I submitted,
हर जगह जहाँ लफ्ज law लिखा हुआ है, इसका एक ही मतलब नहीं है. You have to
मैंने
contextualize it.
at the outset, when I said that laws, two sources, which is this positive law and act of parliament and the judge-made law, so these are broadly two sources of law which the constitution recognizes, which our jurisprudence recognizes. So these are the two sources which we will apply whenever the term law appears, and then see which of the sources fits it.